Can we have the expert come into the room, please? Mr. Forty, good afternoon. Can you please, for the record, state your full name? Can you, turn. Yeah.
So sorry. Good afternoon. Mark Julian Forte.
Okay, you have a declaration in front of you. Can you please read it and confirm that you agree with it?
Would you like me to stand?
Yes, please. No need to stand. Okay. Just read it.
I solemnly declare upon my honour and conscience that my statement will be in accordance with my sincere belief.
Thank you. Respondent has 30 minutes for direct and the presentation, if any.
Mr. President, we don't have a direct. We're just going to allow the expert to do an opening presentation in less than 30 minutes. We just wanted to ask if there are any preference from the tribunal on how the mechanics of the interrogation, if objections are allowed, and if so, on which basis?
No, we would prefer the expert to do the presentation and then proceed in cross-examination, whatever questions there are. And I would ask our secretary to alert the expert when he has 5 minutes left. Okay, so you have the floor.
Thank you. Thank you. Good afternoon, members of the Tribunal Council. I'm a partner in the British Virgin Islands office and head that office of Conyers Dillon Pearman. My credentials include nearly 20 years of practicing BVI law. Before that, I was a barrister in England for 14 years. I have given various presentations of expert evidence before various tribunals and so far not being challenged on the capacity to opine on BVI law. My instructions come from Greenberg Traurig, and I consider my role limited to that advising on BVI legal aspects at the level of the corporate structure relating to SAR as the apparent indirect shareholder of Campos de Pesé. I haven't been asked to consider, nor have I had sight of documents showing the potential ownership structure above SCR. There is an expert opinion by my colleague, Mr. Newton, for the claimant, well-respected practitioner, and I've had the benefit of seeing those reports, and I thought it was more productive for me to give an outline of what is in agreement, because most of our views appear to be aligned in agreement. You will see that, and I've numbered these accordingly. Point 1. On the register of members of a BVI company, it's the name that's on the register that is the holder of the share and is the shareholder in law in the BVI. BVI law recognises that those on the company register are the only ones with legal title over the company shares. The second point we are agreed on, the individuals characterised in the claimant's rejoinder on respondent's objection to jurisdiction, the rejoinder as Italian shareholders, are not shareholders of SCR because they're not listed in the register of members, with the exception of the 13 individuals who are individual shareholders and listed in the register. It's those persons or entities listed in the register of members of SCR, not anyone purported to be a beneficial or ultimate beneficial owner, that has the ability to exercise rights and powers over SCR, such as selecting the board of directors or approving significant corporate actions. Point 4. The duties of directors of SCR as a BVI company are governed now in codified form, previously in common law form, by Section 120 of the BVI Business Companies Act And importantly, they provide that the directors must act in the best interests of the company, SCR. There is a power to expressly provide for directors to owe duties to shareholders, but that is absent from SCR's constitutional documents. For such to occur, it must be specified within the Articles of Association that the director is able to act in accordance with the interest of a particular shareholder. There is no power to allow directors to owe duties to ultimate beneficial owners where such person is not also a direct shareholder of the company in question. The BVI Business Companies Act does not address the question of ultimate beneficial owners in terms of providing rights or direction to directors. Next point, neither Mr. Pellas nor any of the other individuals in the rejoinder characterized as Italian shareholders, nor any purported UBOs of SCR, are mentioned or referenced in SCR's constitutional documents as having any rights or powers over SCR or over SCR's direct or indirect subsidiaries. I think also importantly, next point, there is no voting agreement that I have seen or that I believe exists between the purported UBOs or between the actual shareholders of SCR to vote together or in unison. And I would go further than that because Mr. Newton, in his report, accepts the assumption upon which he bases his report, one of the assumptions being that no such voting agreement is in place. There is a point of dispute between us, and it relates to the BOSS Act, the Beneficial Owner Secure Search System Act. You will probably be aware that the rationale behind the BOSS Act is one of regulatory compliance, of providing transparency as to beneficial ownership of BVI companies. It brings it into line with most, if not all, sophisticated jurisdictions with corporate structures that provides for a basis upon which certain authorized regulatory bodies can, on an international basis, obtain details of beneficial ownership. That is kept away from public view, but is kept carefully monitored and lodged with the Financial Investigation Agency of the British Virgin Islands. Foreign agencies can then apply to have access to that, including, for example, the United Kingdom tax authorities. That search system, BOSS system, was built to ensure the exchange of information with the UK. Under Section 9 of the BOSS Act, the obligation to provide updated beneficial ownership information rests on the BVI company. It's a requirement, not merely a guidance. And in fact, should accurate beneficial ownership not be provided pursuant to the BOSS Act for the purposes of hiding beneficial ownership, or with the intention to deceive in the extreme, any individual or entity who is aware of this, or who has suspicion of this, or subsequently becomes aware this is required to file a suspicious activity report, commonly known as a SAR, sometimes known as an STR, but it's filed with the BVI Financial Investigation Agency. The threshold for that suspicion is low. Regulatory guidance for reporting is contained in the guidance notes on suspicious transaction reports issued by the FAA, and includes where there exists an unwillingness to disclose identity of ultimate beneficial owners. A BVI company that fails to comply with the terms of the BOSS Act commits an offence. That offence can be punished with fine or imprisonment. Now, the information that you would expect to see filed in compliance with the BOSS Act obligations is provided by the company concerned to the agent of a company. In the BVI, every BVI company must have a registered agent, a licensed registered agent. The agent receives information from the company or individuals at the company and causes it to be uploaded into the BOSS secure system. That obligation is for it to be done within 6 months of the filing deadlines within 6 months of the last financial period of the company. Most agents, if not all now, have online tools to allow this to be done automatically with collection of information through the secure system portal. Therefore, in the case of BVI companies in question here, that's SER, and the BVI companies that own shares in SER that I've seen, the directors of such BVI companies should have provided their respective BVI registered agents with the necessary information with regards to their beneficial ownership information. And such information should have been uploaded by the registered agents into the BOSS system. It has to be accurate to be compliant. So the issue that I think Mr. Newton and I perhaps depart from agreement on relates to the significance of the BOSS Act obligations. Now, excuse me, Mr. Newton says, is the BOSS Act relevant to the determination of who possesses the legal capacity to control a company? This is what he addresses. His comment is, I don't consider that the BOSS Act is relevant to the determination of who possesses the legal capacity to control a BVI company, as the BOSS Act addresses regulatory reporting matters as opposed to matters of corporate governance. Now, he's right. The BOSS Act does address regulatory matters, but in doing so, that regulation is a requirement to report accurately beneficial ownership information. So whilst its foundation is regulatory, its substance is important as to accuracy of ownership down the line in terms of beneficial interest. One of the reasons why the obligation exists to do it this way is because it is merely a requirement to have an accurate register of members for the legal capacity of a shareholder. Beneficial owners don't get reported in any register. They get reported for regulatory compliance, but it must be accurate. So the main issue I have with that statement is that the BOSS Act was primarily enacted to provide transparency. BOSS reporting is serious and delicate matter that looks to the substance of an entity's ownership and control, not just the regulatory compliance aspect. Mr. Newton's second comment, from the perspective of the BOSS Act, it is only shareholders controlling more than 25% of the shares that typically get reported, and that in such scenario this would mean, in the ordinary course, any shareholder with less than 25% interest would be excluded from reporting under the BOSS Act. I have 3 points on this that challenge that statement. First, and I'll take you to the terms of the section, but under 6.1a of the BOSS Act, a natural person ultimately would need to own or control at least 25% of the shares in the company in question to be required to be reported as a beneficial owner. But there's a second limb to that section, 6.1b, which also requires a natural person who does not own the necessary 25% of the shares to still be reported as a beneficial owner under the BOSS Act if they, quote, otherwise exercise control over the management of the legal person in question. This case, SER. The use of the term typically is not, I would suggest, quite correct. The accuracy is an absolute requirement. To the extent, I'm sorry.
Am I on? Okay. What does 6.1b exactly mean when it refers to 25% of the shares? It must be that person the sole owner of the 25% of the shares, or that percentage may be satisfied by combining it with the control of other shareholders.
I understand the question. If I take you to the next slide, you'll see the section itself. 6.1a, and hopefully this will address the question. 6.1a is the 25% So the case of a legal person other than a corporate entity who listed on a recognized exchange owns or controls 25 or more % of the shares or voting rights in the company. 6.1b is a legal person not with a threshold of 25% who otherwise exercises control over the management of a legal person. So the key thing I think at this point is to focus on what is a percentage threshold for reporting obligation that triggers identifying a beneficial owner, and the wholly separate question of corporate control of an entity, which is 50% plus one. What you would expect to see, and I slightly jump ahead, but I think it's relevant, what you would expect to see if somebody is asserting that with 26%, I get reported, but I have several colleagues with 24% or 22%, and together we control, that's a bare assertion without supporting that by some measure of voting agreement or some other record of alignment to be able to vote over the control threshold of 50% plus one. If somebody is saying, in fact, and even if I stay away from the notion of Italian shareholders and say it's people with red hair who are shareholders, who vote together, you still need, whatever that pack of voting power is, each one of them on that scenario, because of their agreement apparently to vote a certain way, because of the colour of the hair or the nationality or whatever, they operate control, and they should be reported under the beneficial ownership obligations. Now, in this case, it's not of my interest to verify or examine whether these Italian shareholders are Italian. That's for other people to give evidence of. But where it is said to be a binding factor that says, look, we all vote together, if that is what is being suggested, and that exercises control, then those individuals should be either evidenced in some form of voting agreement where you can point to the fact of control, because remember, none of them individually are over 50% of the corporate control of the company, then they should be reported in the register. And in this case, they are expressly not reported, or at least what I've seen so far, certainly from an exhibit to my friend's report, under the registered agent certificate, it's just Mr. Pellas who's reported as a UBO. Now, and that presumably is because it is suggested he has control. But, and if I go back to the slide, I don't know if that's addressed your point sufficiently for the moment, but you will see that's the difference in the two subsections of the law. And so, if I go to the next slide, the third point is that Mr. Pellas does not own shares in SER. We've seen that. The rejoinder argues he indirectly holds an interest in SER through Travers Atlantic, and even I've heard about Travers Atlantic being submitted this morning, which is a BVI company. But it does not own 25% of SER, let alone 51%, but 25%. So Mr. Pellas is the only person listed in the registered agent certificate as being the UBO of SER for the purposes of the BOSS Act. On what basis that is made, I can't comment. I've not seen the BOSS filing itself. I've seen the agent certificate that records that's what's being said. In any case, what's clear from the rejoinder, Mr. Pellas alone would not have the sufficient number of indirect shareholdings in SER to be able to indirectly form any kind of control over SER from a corporate control perspective. That's 50% plus one, and subsequently indirect control over Campos de Pesé. He doesn't, in fact, have directly or indirectly even the 25% that triggers the automatic filing obligation, yet he is reported as being UBO. The only explanation I feel I can come to from that, as to why Mr. Pellas would have been reported under the Boss Act without allegedly controlling 25% plus of SER shares, while other supposed Italian shareholders, who are also said to control SER, supposedly together with Mr. Pellas, were excluded from the Boss Act reporting, is that they do not actually exercise any control over SER as one definitive unified voting bloc. If they did control SER, they're not reported as doing so, and SCR would be seen as being in breach of BVI law for failing to report its UBOs under the Boss Act. The company would be in breach. More so, if the persons did actually exercise control over SCR as one definitive voting unified bloc, it would be standard market practice for this to be documented in a shareholders or voting agreement. And I have not seen that, I'm not aware it exists, and Mr. Newton assumes in his report one does not exist. My conclusion on points of BVI law from this is that it's irrefutable under BVI law that the register of members and the constitutional documents of SCR do not show a majority Italian ownership of SCR because, pursuant to BVI law, ownership of registered shares in the BVI company is determined by the persons on the register of members of SCR as shareholders, and as such, shareholders are entirely responsible for the decisions and direction of SCR as a legal entity with separate legal personality. Let me pause there. The duties of the directors appointed by those shareholders, even if it is said that in fact various nationals, and I can't confirm whether they are Italian nationals, that's not my job, but various persons have the majority of the board of directors on a day-by-day basis. Well, so long as there is no majority of the ownership of the company, there's no arrangement to control 50% plus one of the ownership and control of the company, that board can be removed in a click of a finger because control and power of the shareholders lies elsewhere. So it's a bit like having, with respect, cake and eating it. If you're going to have control and base that control upon an alignment or a voting agreement, then you must report you have that, and you have more people who are involved in the control of the company. Mr. Newton is right, it's a regulatory issue about reporting, but it's also corroborative of the assertion that other people control. And if you do not identify people together having control, you with respect, can't have it both ways. My second conclusion point, BVI companies do not owe any fiduciaries to the ultimate beneficiaries of such companies. That should be recognised, and it is a matter of agreement between us as a common theme for corporate structures across the world. In the BVI, you can allow for direct duties to shareholders if you provide for it, but there is none here in these documents. So the BVI directors owe a fiduciary duty to the company itself. No matter who directs what they should be doing or who says you should really think about this or that, if they are not obliged to act in the interest of the shareholder, they must act in the interest of the company. Now, it may be said in many occasions, some occasions, that the interests of the controlling shareholders are the interests of the company. It doesn't follow automatically. But in this case, I'm identifying that the UBOs are not owed any duties by directors of the company. And where a BVI company has multiple directors, such as SCR does, no single director, even a chairman, has the power by himself to control and direct the affairs of SCR and its subsidiaries. It can be delegated, it can be given. It's not, in this case, there is no specific power to any one person, such as the chairman. Nothing in BVI law or the constitutional documents of SCR gives SCR directors that power. To effectively pass a director's resolution pursuant to the articles of SCR, at a minimum, requires the affirmative vote of at least a majority of directors, as you would expect. In a board of 7, that's 4. There's no great magic to that. It's a simple majority vote. And those are the conclusions that I reach. If I can assist, Phil.
Thank you so much. We give now the floor to claimant for cross-examination.
Thank you, Mr. President. Refer to Tribunal's Procedural Order number 4. It memorialized that on June 13th, we had indicated to counsel for respondent that we withdrew our request to examine Mr. Forte, and respondent said that it nevertheless would like to have him come, have him present. Thank you for coming, Mr. Forte. Listened carefully to your presentation. But members of the tribunal, we have no questions for Mr. Forte.
I had a question, but I think it has been answered, so no questions for the tribunal either. Mr. Forte, thank you very much for your presence and your presentation. You're now free to go.
And much obliged.
Shall we then move to the next expert that we have for today, Mr. Jaime Mora? Rather than doing a break, which I don't think is necessary.
Sí, vas a leer en español.
¿Sí?
Tienes tus notas.
Sí, sí, aquí tengo la...
Bueno, está bien. Es para que cuando tienen preguntas tienes tus exhibidos ahí.
Ok. Gracias.
Buenas tardes, señores.
Good afternoon, distinguished members of the tribunal, Mr. President.
Want to testify in Spanish
Sí.
or in English? In English.
Español.
En español.
Spanish. Fine.
Can you please, para el récord, puede dar...
For the record, could you please give us your full name? I'd be pleased to do so. My name is Jaime Mora Solis. I'm a Panamanian citizen. I'm an attorney. And you have before you a statement, a declaration. If you could please read it out. Yes, I'd be pleased to do so. I think it's been provided to you, but I'd be pleased to do so. I'm a graduate of the university. No. This is the expert declaration. There's one in English, one in Spanish. No, they're both in English.
On my honor and conscience that my statement will be in accordance with my sincere belief.
Gracias. Are there going to be any questions, or should we proceed directly to the presentation?
I have just one question, Mr. President. Mr. Mora, could you turn to the binder in front of you? You should have there a copy of your report.
Mm-hmm.
If you open that, the first document in there should be the report.
Yes.
And if you could just turn to the back on the last page there and verify for the tribunal that that is your signature.
Yes, that's my signature.
All right, you can proceed with your presentation.
Gracias. Doctor Mora, usted tiene la palabra.
Thank you. You have the floor for 30 minutes. We'll let you know when 5 minutes are left to help you end on time. So go ahead. As I was saying, I am an attorney, graduate from the University of Panama. I have been a professor of civil law at the University of Panama and commercial law at the University of Santa Maria la Antigua. I obtained a master's at Tulane University in New Orleans, and I have practiced law since 1976. It's 1973. I'm a member of a Panamanian law firm, Arias, Aleman, and Mora. And that's basically the relevant personal information. I'd like to clarify that my opinion will be an opinion on Panamanian law. I'm not going to get into analyzing any particular corporation, not Campos de Pesé or any other. Rather, I'm going to talk about Panamanian corporate law in general terms. That's the opinion that I'm going to give. First of all, the points I intend to deal with are first, how under Panamanian law control is exercised over a Panamanian corporation. This under the Corporations Law of Panama, in force from since 1927 and to this day. I've been asked, and I'm going to speak of, the aspects of control, as I say, and also the question of the final beneficial owners of shares issued, and under Panamanian law, what happens where the shares of a corporation are held by a person through different intermediate corporations. Those 3 points are the ones I intend to develop, unless you have any subsequent questions. The Law 32 of 1927, Panamanian Corporations Law, governs all questions relating to corporate control, administration, regulations of relations among shareholders, directors, administrators of record, and dissolution, amendments to the Articles of Incorporation. All of these aspects relating to corporations are regulated by a single law, which is the law that I've mentioned, Law 32 of 1927. Under Panamanian law, very similar to what we just heard about BVI, and following the guidelines in Delaware and Oklahoma corporations law, the day-to-day operations, the management of the company, the administration of the company, corresponds to the board of directors. The board of directors in Panama must be made up of at least 3 directors, unless the director is a corporation, in which case that number of directors is not required. But if the directors are natural persons, then there must be at least 3 directors. Now, depending under the law, the corporation is administered by a board of directors. Nonetheless, the shareholders retain 2 important powers, significant ones. One is the right or power to amend the Articles of Incorporation. Amending it corresponds to the general meeting of shareholders. And second, another very important power of the shareholders is electing the members of the board of directors. The members of the board of directors in principle, unless the Articles of Incorporation provide for some limitation, they are to be chosen by the shareholders of the company. While the administration of the day-to-day activities of the company corresponds to the board of directors, and therefore their functions are essential for management of the company, the supreme power of a corporation in Panama lays with the general meeting of shareholders. The shareholders, they may not be deprived of their rights unless they themselves establish some limitation in the Articles of Incorporation. It's the shareholders who exercise ultimate and absolute control over the corporation, even though the administration of the company is a basic function of the board of directors. Article 49 of the Corporations Law of Panama is very clear. It states that the business of the corporation shall be administered and directed by a board of directors composed of at least 3 members. But then Article 50 indicates that while the board of directors shall have absolute control and full management of the transactions of the corporation, the shareholders retain the powers to elect the board of directors and to amend the Articles of Incorporation. Now, moving on to the topic of the final beneficial owners of the company, it's a concept which in Panama came up quite recently, around 2015. The principle of a final beneficial owner in Panama is important primarily when it comes to ensuring that the necessary controls are in place so as to not abuse of the law. The question of double taxation was what led and gave origin to the principle of the ultimate beneficial owner, or final beneficial owner. And that's really what it's about. Now I can confirm that the powers of control and management of the corporation are exclusively in the hands of the directors, but the shareholders are the ones who, at the end of the day, have absolute control insofar as the shareholders have the power to remove the directors, just as they have the right to appoint the new directors. Also, the shareholders retain the right to amend the Articles of Incorporation. This is a power that the Board of Directors does not have. The Board of Directors has no power to amend the Articles of Incorporation. Now, finally, I want to underscore that the fact that a shareholder owns shares in a company through another corporation, at the end of the day, doesn't diminish the power of the shareholder, because it will, he or she will cast their vote through that intermediate corporation, which would be the direct shareholder, and then shareholder. In this case, that person would be an indirect shareholder, but ultimately has control of the corporation. This is quite common in Panama, where we encounter a corporation whose shares are in the name of another corporation or other corporations whose shares in turn are in the hands of the final beneficial owners. Those are the main points I wanted to highlight, and I'm ready to answer any questions you may have. Thank you very much. I now give the floor to the respondent for the cross-examination. Thank you very much. If I may begin with a statement in your report, which is written in English. I'm going to read it out in English, if I may. In your report, it says,
The company is accorded to its shareholders, directors, and administrators of record. Estamos de acuerdo en que el
so we agree that the control of a Panamanian company, therefore, is held by the shareholders of the company, the directors of the company, and the administrators. The administrators and the directors actually serve the same function. Agreed. Now, I know you mentioned in your testimony that you were going to base your statement on Panamanian corporate law generally. Nonetheless, in the supporting documents that you cite, you refer to some of the deeds, such as those of Panama Sugar Estates. You recall? Yes. Now, am I right that Campos de Pesé at no time has had an Italian shareholder? Based on my knowledge, it doesn't have any Italian shareholder. But I emphasize that generally in the public registry does not reflect the names of the shareholders of the corporations. That is regulated internally by the company, and in the book of shareholders, that shows where who they are. I mention the public documents that you cite in your report because I'm right that some of these public documents, for example, when they amend the Articles of Incorporation, reflect that the shareholders met, voted, and it might reflect the number of shareholders. They may do so, they generally don't. What is stated in the amendment, where there's an amendment, is that all or the majority of the shares have been present, all the outstanding shares, but the names are not usually identified. Also, when there is an assembly of shareholders that appoints or directors, that is also, or removes directors, that's also a matter of public record, yes. And that reflects or may reflect the names of shareholders. It may. So based on your knowledge of the documents that you had the opportunity to review, Panama Sugar Estates has never had Italian shareholders either, correct? Not as far as I know. So neither Campos de Pesé or Panama Sugar Estates have had Italian shareholders with the exception of Carlos Pelas. Could you repeat that, please? Of course. Neither Campos de Pesé or Panama Sugar Estates, with the exception of Carlos Pelas, have had Italian directors, correct? I don't know that they're Italian, but I've heard here that he is Italian, or they are Italian. So he would be the only one, or they would be they would be them. And am I right that in the public registry in Panama, the companies also register general powers of attorney? Not necessarily. Before, general power of attorney had to be registered in the public registry. It's no longer necessary. It might be in private documents. It doesn't have to be a public one. And the documents that are in the public registry of both Campos de Pesé and Panama Sugar Estates, you've never seen a general power of attorney issued to an Italian, correct? No. Well, I don't know if the persons to whom powers of attorney have been granted are Italian or not. I've seen powers of attorney, but I don't know whether they're Italian or not. Certainly you've never seen a power of attorney granted to Carlos Pelas, have you? That I don't recall having seen. Would you also agree that on a board of directors of a Panamanian company, the directors have to vote as a collegial body, correct? Yes. That means that no director makes decisions alone, correct? Unilaterally, one could not make such decisions. One would need the vote of the other members of the board. Now, the corporation can give a power of attorney to a given person, but the decisions of the board of directors are collegial. And according to the articles of incorporation that you have seen of Campos de Pesé and Panama Sugar Estates, they don't give any special power of attorney to Carlos Pelez as director of the company. I don't recall having seen that. You don't recall having seen a veto power. He doesn't have veto power in those companies. No, I haven't. Generally, such veto power doesn't exist, or it's not registered. It would only be a private agreement among the shareholders who might decide how to handle things among themselves.
We also agree, Mr. Mora,
Los beneficiarios.
that the UBOs of a Panamanian company do not have the power to control and manage that Panamanian company. Administratively, they don't. They have the power to change the articles of incorporation and to choose the board. Just to clarify, I'm asking you about the UBOs. We agree that the UBOs of a Panamanian company do not have the power to control and manage that company, right? To the extent that they are shareholders, they do have control. I'm using very specific terms here. I'm not asking about shareholders of a Panamanian company. I am asking about the UBOs. Yes, indeed. And the UBOs, if they're not shareholders, registered shareholders, they do not have the power. They don't have the power to control and to manage the company, right? Correct. I'm going to ask
Ryan Fulham to show for us exhibit from claimant 204.
People at the last level have any sort of control over the Panamanian company, regardless of what the applicable law to the different levels is. So I don't think he's being asked on anything on BVI law.
Si pudiéramos ir a la página
Excuse me,
siguiente.
Mr. President, I just wanted to clarify that every company in between here, there's two Italian and there's BVI entities. If my colleague wants to examine him about those Italian shareholders who hold shares through Panamanian companies, I think that's fine, but he's not testified about the holding of these Italian nationals through.
No, we're
the shares
not
of the
discussing
BVI.
Italian nationality or anything. We're simply asking him, and it's of interest for the tribunal to know, what is control on the Panamanian law? And this is the structure that you have presented, and he's being asked whether at the lower level, at the second level, at the third level, who has control? I think is a perfectly viable question.
It is a perfectly viable question if any of these entities were constituted under Panamanian law, right?
No, because he is being asked about what is control for purposes of Campos de Pesé, that is a Panamanian company. So he's being asked whether companies with these percentages, regardless of where they are incorporated, whether they are Italians or not, what is the level of control, if any, that they have under Panamanian law over Campos de Pesé? I think is a fair question.
I apologize for the intervention. I simply wanted to make sure we were clear that these intermediate companies are BVI companies.
¿Puedo proceder?
May I proceed? Says the lawyer. The individuals under there in green, what is the nature that they have? I don't know what powers they have. Are they shareholders of SER? Are they directors of SER? Who are they? I don't understand this very well. Okay, very well. I see your question. I'm going to represent to you in good faith what the claimant has indicated, that these individuals here under this chart, these are individuals who are shareholders of the companies that are shown here as PAN. So, giving you that context, I'll ask again. The individuals here on the chart do not have powers of control and management over Campos de Pesé, right? Not directly, no. They have control on the companies on top of them until the end. You are talking about indirect control, right? Yes, indirect control. I'm going to read your statement, and here in your statement you say the following.
Dice las leyes recientes panameñas, discutiendo las leyes de beneficiarios finales. No accord or grant
I'm going to cite this in English.
the final beneficial owners of a corporate entity any right or power of control of the respective entity, either directly or through intermediaries or third legal entities owned by the final beneficial owner. Esas son sus...
Those are your words. So applying your words to this structure that I'm showing over Campos de Pesé, not directly. I insist. You're using the word directly to answer my question, in spite of the fact that your statement says that UBOs do not have indirect or direct power over a Panamanian company. I would say neither direct nor indirect.
Si me permite ahora...
If you allow me, Mr. Mora, you can call me Jaime. Mr. Mora, okay, Mr. Mora. If you allow me, Mr. Mora, I'm going to read a phrase in English of your report. It is paragraph 18 of your report, and I'm going to read it in English.
El párrafo dice that a shareholder owns shares through an intermediary entity does not impact the basic principle of Panamanian corporate law. As long as a shareholder maintains control of a company, ownership of shares through an intermediary does not sever the shareholder's control over that company.
Correcto.
Esa es una afirmación.
That's an assertion in your report, right? Yes, and I confirm it. At that paragraph in your report, you cite a regulation in Panamanian law? I don't think I do, no.
Ese último párrafo no.
I do not cite any provision there of Panamanian law, but it's a general principle of law in Panama. You'd agree with me that there is no provision of Law 32 that refers to indirect shareholders. I haven't seen that, no. Please speak close to the mic. Your answer was that it doesn't exist, right? No, it does not. You'd agree with me that the Commercial Code of Panama does not regulate, mention, or cite the concept of indirect shareholders. It doesn't do it either. You'd agree with me that Law 32 does not mention or regulate the concept of intermediary entities as shareholders. It does not. And the Commercial Code of Panama does not cite or regulate the concept of intermediary entities as shareholders. It does not do that either. Let me add something. Yes, of course. It does not regulate that. It does not establish that, but it is a situation of fact. It's not a legal matter. If an individual has shares in a corporation and the corporation has shares in others, so that person could have control through that other company of the shares of the other company. So the alleged UBOs exercise control and had decision power on the Panamanian company. Yes, well, but not in this particular case. I'm talking about generally. Finally, Mr. Mora, I'm going to ask you a few questions about the issue of the UBOs and resident agents. If I understand correctly, today in Panama, after the different rules and regulations that we have discussed, there is an obligation by resident agents to provide information to the Superintendency of Non-Financial Subject. Yes, of course. If not, they get a fine. And all the companies should have a resident agent, right? In Panama, they should have them. This has been a simple process, right? For the resident agents to ask their clients to report to them their UBOs so that the resident agents can upload that information. That's right. We do it. Not all of the clients provide the names to us or comply with the request. The solution would be to renounce being a resident agent. You need to speak closer to the mic, sir. So we actually do it. Not all of the client, you said? The resident agent asks the client to submit to it information of the shareholders or of the ultimate beneficiaries of the corporations of which that person is the resident agent. It is an obligation to ask for that information. If the information is not given to us, then we have to step down because if not, the superintendency of companies fines us and imposes on us very harsh sanctions. Your law firm is, for some clients, a resident agent. Yes, sir. Galindo, Arias, and Lopez. It's a law firm that is a resident agent for Campos de Pesé. You know it, right? Yes, it is a well-respected and well-known law firm. Let me clarify that in the past I was a member of that law firm. I was also a partner at that law firm, just to avoid all doubts, many years ago. In the general course of business, we could assume that Galindo, Arias, and Lopez is a prestigious and recognized law firm in Panama asked Campos de Pesé the information on its UBOs. I would be surprised if it didn't. And Campos would have given it to it, possibly. Okay, if not, Galindo would have a problem. For Campos de Pesé, would have the information that it provided to the resident agent. Yes. I'm also correct, right, in that UBOs are defined by the law as natural persons that exercise final control of the legal person via other means. Yes, that's correct. If the individuals that I show you at the end of these charts were the UBOs of Campos de Pesé would have had to report this to Gales, Galindo, and Lopez, right? Yes. And Galindo, Arias, Lopez would have to report that to the Panamanian government, right? Yes, indeed. I have no further questions, sir. Thank you.
Claimant.
I have just two questions, and if you need the headset, please let me know so you can hear the Spanish.
No, that's fine.
Okay. Do you recall in what year the UBO regulations you discussed came out in Panama?
Creo que 2015.
I think in 2015. And then in 2020 there was another law. I'm not entirely sure, but I think 2015. I don't think I have it here. 2015, I think.
To the extent that you would expect to find reporting for Campos de Pesé, would it be before or after that date?
Could you
Repítame.
Yes. To the extent that you would expect to find some UBO reporting for Campos de Pesé, would it have come before or after?
After.
That legislation? Okay. That's all, Mr. President.
Doctor Mora, muchas gracias.
Mr. Mora, thank you very much. You have been quite useful for the tribunal. We have no further questions for you. You can step down. We do have some time left today. I don't know if we can perhaps go on to the next witness. I'm curious to know, would it be possible to examine Mr. Lindley today or not? Yes, Mr. President. He is on his way. We hope that he gets here in about 20 minutes for him to be available.
I think you're doing the cross, so.
I'm sorry, I had the headphones on.
Yeah, the issue is whether we can, given that the early time, whether we can proceed today with Mr. Robert Lindley. But of course, you are doing the cross, so.
Yes, Mr. President, we can.
Okay, so we'll take a break of 15 minutes now.
Did I understand he?
He's on his way, and we
Yeah,
expect
he's on
him to
his
be
way
here.
here. He's on his way.
And you said 20 minutes.
Hopefully 20 minutes.
Okay, so why don't we take then a 20-minute break
Okay, thank you.
and then resume with Mr. Lindley for today.
Thank you, Mr. President.
Thank you.
Thank you, Mr. President.
Okay, can we call Mr. Lindley, please? Good afternoon. Can you please, for the record, state your full name?
It's Robert David MacDonald Lindley.
Thank you. You should have a declaration in front of you, please.
I solemnly declare upon my honour and conscience that my statement will be in accordance with my sincere belief.
Thank you. Respondent, you have the floor.
Thank you, Mr. President. We have no direct. Mr. Lilly will proceed directly with his presentation.
Okay. You have 30 minutes for your presentation, as you know.
Thank you. I'm a partner and head of the Cayman Islands and British Virgin Islands private client and trust practice of Conyers, Dillon, Pearman. I've been in practice as a lawyer for 20 years, with the last 10 years practicing as an attorney in Cayman. I regularly advise on matters relating to Cayman Islands law governed trusts, and I've given expert evidence on matters of Cayman law on a number of previous occasions. I've been advised by my instructing counsel, Greenberg Traurig, that the extent of my role is to advise on Cayman law in relation to the trust structure as detailed on the organisational chart overleaf. I've not been asked to consider, nor have I had sight of documents showing the potential ownership structure underlying the Cayman trusts and their directly held assets. I prepared my expert opinion dated 20th January 2023 on Cayman Islands law in relation to Cayman trust structures and based on a review of documents available at that time, the Lindley opinion. I've reviewed the expert opinion dated 27th of April 2023 of Henry Mander, including the documents exhibited thereto, the Mander opinion. This summary presentation summarises certain points raised in the Lindley opinion, and having had the opportunity to review the Mander opinion and the documents referred to and exhibited therein. This is the
Thanks very much. Claimant, you have the floor.
Excuse me. Good afternoon, Mr. Lindley. I just wanted to ask, do you have a copy of your report in front of you? No? Okay. We'll put it up on the screen, and then you should be able to see. Okay. So just, I wanted to start by asking, you were retained by Greenberg Traurig as an expert in Cayman Islands.
Excuse me, can you get a little closer to the microphone? Because...
Apologies. Okay.
Thank you.
I just wanted to confirm, you were retained by Greenberg Traurig as an expert in Cayman Islands trust law, correct?
That's correct, yes.
Okay. And when were you retained?
Back in, I'd like to say December 2022.
Okay. So, okay. So we can put the entities aside for a moment. You mentioned that in preparing your testimony today, you reviewed Mr. Mander's report, correct?
Yes, correct.
Did you also review claimant's rejoinder on objections to jurisdiction? Was that provided to you?
I don't believe so, no.
Okay. I'd like to show you some exhibits that you may not have previously reviewed and just ask you a few questions. So could we put on the screen Exhibit C0242? Have you seen Respondent's Exhibit R0017? We can put it up on, oh no, sorry, we won't put it on the screen. But are you familiar with the Respondent's Exhibit 0017?
No, no.
Okay. Okay, thank you. I have no further questions.
Thank you. Respondent.
Mr. Lindley, has Mr. Mander cited to any document that shows that PTC owns 10,000 shares in Atlantic Corp?
No, not 10,000 shares of Atlantic Corp, no.
The registry of members of Atlantic Corp shows that PTC holds 5,000 shares, correct?
5,000 issued shares, that's correct, yes.
For the record, the registry of members of Atlantic Corp is at pages 24 and 25 of Exhibit R0021. It doesn't show that PTC owns 10,000 shares, correct?
Correct.
Have you seen any document at all that shows that PTC owns 10,000 shares in Atlantic Corp?
No, I haven't, no.
Thank you. Has Mr. Mander cited to any document that shows that Mr. Pelas or anyone else contribute PTC's shares in Atlantic Corp to the Atlantic Trust as trust property?
No, not at all. The register of members just shows as an allocation to Travers PTC. There's no documents that evidences that Mr. Pelas transferred or directed a transfer of any assets.
Thank you. Have you seen any document showing that PTC's shares in Atlantic Corp are the trust property of the Atlantic Trust?
No, not specifically. The trust deed is silent in respect of Travers Atlantic Corp.
One last question. Have you seen any evidence that Mr. Pelas ever exercised any of the rights and powers that opposing counsel asked you about?
Not any of the powers that are reserved to Mr. Pelas under the trust deeds, other than his direction for a change of trustee, but he didn't exercise the power of removal. There's no evidence in respect of that, in respect of the deed. But I've seen no documents that evidence Mr. Pelas' exercise of any power.
Okay, thank you, Mr. Lindley. So we don't have any further questions.
Yes, maybe one question. Yeah, maybe one question again to both parties. I would like you to specify what you understand by control, because you have showed us a lot of actions that could only be done with the authorization or the acceptance of Carlos Pelas. But I find it mainly administrative organization, and I didn't see that he could change the power of the trustee. He could change the trustee, but not the power of the trustee. And for example, just looking at the last document, you were discussing the Travis Trust, HM10014. First page, it's written, the original trustee has received or has otherwise had placed under its control the property specified in Schedule 2. And Schedule 2 refers to the 1,000 shares in PTC. So this cannot be changed, if I understand. So I would like both parties to, be more precise on what really is the essence of control.
But should we not go to the expert first?
Oh, yeah. Of course.
Yeah, before the parties go to
yeah. Sorry for that. Yeah, of course, it's a question for you.
Yeah, this is, and if I may complement that, you refer in a number of sections of your report that the fact that Mr. Pelas has reserved some powers does not affect the nature and integrity of the trust. Can you explain that? And in that regard, whether or not the trust gives the trustee or Mr. Pelas or both control over the assets, not ownership,
no,
control.
Yeah. I'll start with the question in the middle first about the reservation of powers. So under Cayman Islands law, it's a specific section within our Trust Act that provides for reservation of powers at section 14. And there's a non-exhaustive list of powers that can be reserved to a protector. And it clearly expressly provides in our legislation that any of the reservation of any or all of these powers does not affect or invalidate the trust itself. So in essence, what it's saying is that a settle can reserve powers, but it doesn't change the fact that the trust assets have been transferred to the trustee as the owner of the assets, even if the settlor has reserved certain powers that may affect how the trustee can deal or administer the trust in respect of those assets. So that's the reservation of powers. But about any degree of control, I mean, it goes the same thing again, really. So Pellas as settlor, he can reserve powers. It doesn't give him ultimate control because these powers, they're over certain provisions or certain actions of the trustee. So whether the trustee is going to maybe, in this case, distribute income, well, it's reserved, the settlor then will consent to that. But it doesn't apply to the distribution of capital. It's only to the income itself. It still doesn't change the fact that the trustee, the buck stops with the trustee. It's the ultimate decision maker. So when a trustee then thinks, well, there's a request from a beneficiary for a distribution, it's the trustee that makes the decision. It takes into account all of the material considerations as to whether or not that distribution should be made to that particular beneficiary. But in exercising that power, the trustee will then seek the settlor's consent.
What is the purpose of the trust? Because we're talking about transferring the assets. So how are the assets handled? What is the purpose itself of the trust? This is under Cayman law, of course. I'm not asking you to opine on any other law or as a general point.
Of the Travers Atlantic Trust.
Of a trust in general, this
okay,
nature of
sorry.
trust, and of the Atlantic Trust in particular. But what is the purpose of the Cayman law of a trust of this type?
Well, it's going to depend on the settlor's requirements and circumstances. I mean, the general examples, as I mentioned at the outset, it's for asset protection or bankruptcy remote. So by transferring assets to a trustee, the settlor is divesting himself of title to those assets. He's taking them out of his own ownership, out of his own estate, and then vesting it with the trustee's legal owner. So the reason why, or the purpose of these types of trusts in Cayman, it's to take it out of assets. You don't have to deal with probate. Sorry, take it out of the estate. So you don't have to deal with probate or inheritance, or it's taking it out so it becomes bankruptcy remote. So creditors can't attack it because the settlor is no longer the legal owner. It rests with the trustee. And then we also have specific legislation in Cayman that provides that you can't enforce a foreign order, or a foreign order isn't recognised in respect of a Cayman trust. It's called our firewall legislation. It's quite common throughout the offshore world in respect of trusts. And that's the reason why settlors use this, to protect their assets from attack.
The last question refers to paragraph 323 of your expert report. You say the trust is discretionary in nature with regard to income of the trust. And then the very last sentence, nothing that the trustee's power to pay income is subject to Pellas or settlor directing the trustee to pay income. Such decision is ultimately the trustee's. Can you explain that?
So the trust fund, you have the capital of the trust fund, let's say being the asset, and then there could be income that's deriving from that asset. So think of the trust fund being split into two categories, the income part and the capital part. Under this trust deed, it's discretionary in nature because we call trust discretionary in nature because the beneficiaries of the trust only have a mere expectation of a hope of receiving distributions. They don't have a fixed interest. The trust doesn't say, beneficiary X is able or entitled to 50% of the trust assets or 50% of income. This trust deed is silent on that. So it's discretionary, meaning it's the trustee, in whichever way it thinks fit, makes that distribution to the beneficiary if it's the right thing to do, if they've taken into account all material considerations, whether or not the trustee will do that. In this case, in this trust deed, the distributions over income, there's a power reserved to Mr. Pellas that the trustee obtains Mr. Pellas's consent, but not in respect of capital. It's an unfettered discretionary power of the trustee. The trustee is the ultimate decision maker in respect of any distributions of capital. There's no check, consent, approval that's required.
And one final question. If shares are put in trust, who has the power, to control, to vote those shares in the trust?
Well, the trustee as shareholder will have shareholder powers and approval in respect of those shares.
Okay.
I am concerned that maybe we are playing with semantics here. What does control mean? And I would like to know if under Cayman Islands law or common law, there is some notion of control that we can put our hands off to understand exactly what it may mean. What I have heard from you, for example, is that control relates to the possibility to dispose of the trust funds. But if the trust funds are controlled by somebody else in terms of how to administer them or how to otherwise use those funds, what does the notion of control mean?
No, precisely, and we don't use that word, and we don't have a statutory definition in our trust law in respect to control. It's all about the reservation of powers in respect of the administration or the disposition of assets, where the trustee, there may be powers that reserve to settle where there's an approval or a check and balance or a consent process. But control, you're right, it's not in there. It's nothing that we talk to. And in fact, if there was too much control, it's actually more of an onshore issue, because too much control means that everything is vested in one particular person, and the trust in the end could be a sham, potentially. If someone, when they should have divested them, so the settlor should have divested him or herself of assets by transferring them to the trustee, well, that's the ultimate aim. That's what you want to do. You wouldn't want to retain too much control, whatever that may be, because that could not under Cayman trust law, but from an onshore perspective, it could actually could be adverse implications for the trust.
Mr. Lindley, we thank you for your time and your patience. You're now free to go. We ended up early today, so we're going to continue tomorrow at 9. Thank you so much.
Thank you.
Thank you, Mr. President. Thank you, members of the tribunal.